Hi everyone, and welcome to this Fieldfisher Data Protection webinar. Today we will be talking about, that's not quite where we have to be. Yes, today we will be talking about inspections and enforcement in Belgium, and we will share practical tips to help you be prepared better. My name, for those of you who don't know me, is Tim Bankanet. I'm a partner in the top team of Fieldfisher Brussels, and I'm joined today by Louis van der Donkt, who is associate in our team. Now, before I hand over to Louis, who will share some insights on the Belgian DPA's enforcement trends, I want to quickly address a few housekeeping points. First, as you may have heard, this webinar is being recorded and will be made available on Fieldfisher's Privacy YouTube channel, which also contains the recordings of other recent webinars. And then second, if you have questions, feel free to share them using the questions functionality. We will either try to reply to them as we go along or address them at the end of the session. With that said, I hand over to you, Louis.
Thank you, Tim, and indeed, thank you everyone for joining our webinar on GDPR enforcement in Belgium. Now, as Tim already said, I will be walking you through a recap of the Belgian Data Protection Authority's enforcement practice over the past 3 years. And in doing so, I'll be looking at what the DPA's priorities have been, what type of cases it has dealt with the most, and what the DPA's approach has been so far in terms of fines and how this compares to other countries. We'll also have a look at the body of case law and appeal before the market court, and I'll finish off with a glimpse of what we can expect next from the Belgian DPA. So, as you see on the slide, as the Belgian DPA indicated itself, a cornerstone in its enforcement approach has been its strategic plan for 2020 to 2025. The plan is structured around 3 pillars on which the DPA intends to focus. First, on specific sectors, for example, telco and media, direct marketing, and all the technical means used for that purpose, such as the use of cookies. Then there are certain GDPR topics on which the DPA puts specific emphasis, like compliance with the obligations relating to Dpos, is the DPO designated, is it independent, etc. And then certain societal topics, like, for example, online data protection. So if you go to the next slide, please. Now, with the GDPR applying for almost 3 years, we glanced back at the body of case law of the DPA to see whether these priorities are actually reflected in its decisions so far. Just to be clear, we've looked at all the penalty decisions of the DPA. So this is not only the fines, but also reprimands, orders to stop a certain processing activity, orders to bring the processing in line with the GDPR. Now, of all the decisions the DPA took, we see that most of them have started with an individual complaint. In fact, 45 out of 52 penalty decisions are complaint-based. Of course, the DPA has little control over what complaints it receives and whether they are situated within its strategic priorities. However, we've seen 3 ways in which the topics from the strategic plan have ended up in the DPA's decisions nonetheless. Firstly, we've seen that the inspectorate takes a driving role to include the topics of the strategic plan in the cases brought before the Litigation Chamber, and it does so by broadening the scope of the investigation to those strategic topics, for example, by including questions to the controller on, say, the position of the DPO. Secondly, for all the cases that have been started by the Directorate, we see that all 6 of them so far are situated within the strategic priorities. And then finally, the DPA also influenced a number of cases within its strategic priorities via the cases that it dismisses. In fact, there have been various instances where the DPA has dismissed a case because it did not form part of the strategic plan and because the DPA didn't consider the case important enough for a lack of a big enough societal value. Now, it's worth mentioning here that the market court has already invalidated such dismissal decisions twice for a lack of proper motivation. Okay, and then we've seen that only 3 cases have started with a data breach notification. Now there are 2 important takeaways from this slide. First off, it's worth looking at the GDPR topics that are included in the strategic plan. Even if you receive a complaint that has nothing to do with the strategic priorities, chances are that the inspectorate could probe you on those topics nonetheless. And then secondly, the amount of cases that have started with a data breach notification are quite limited. So if you have a data breach and you're not sure whether you want to report it, know that so far the DPA has rarely followed up a data breach notification with a penalty. Okay, now let's have a look at some figures. Tim, next slide, please. So on this slide, the purple bar represents all the penalty decisions across the respective sectors. The blue bars shows how many of those penalties were administrative fines. Now, there are a few points that are interesting on this slide. We see that the DPA has a high tendency to issue a fine in those sectors from its strategic plan. All the penalty decisions it took in the direct marketing sector were administrative fines, and that's 4 out of 5 decisions in the telecommunications and media sector. In the public sector, we see that there's more discrepancy, which is in part explained by the fact that the DPA cannot issue a fine on public authorities. Finally, the other category represents ad hoc cases in all types of contexts, often solved with a reprimand, a warning, in order to bring a processing in line with the GDPR. Next slide, please. On the societal topics, we clearly see that most cases are situated in the other category in a way that makes sense, as this is not something the inspectorate could influence through targeted questioning. Here, the DPO mostly takes what is brought to its attention through complaints. We also see that there's a high fine ratio for issues in the online data protection realm. And then finally, the GDPR topics. Next slide, please. We see that the largest chunk falls under lawfulness and fairness, which in all fairness makes sense, as this is really relates to the broad principles under the GDPR. Now, those keen observers amongst you might have noticed that there seem to be more cases on here than actual penalty decisions. That's because there is often an overlap between various topics. For example, non-compliance with the right to object of a data subject or with the request for deletion could amount in an unlawful processing, thereby ticking 2 boxes at once. So next slide, please. Another tendency that's worth pointing out is the increasing frequency with which the DPA is issuing its decisions. So as you know, there was not much activity from the DPA until April 2019, when the members of the Direction Committee had been appointed. And after that, it took some time for the DPA to get warmed up. The DPA only issued 11 penalty decisions throughout 2019. However, in 2020, we've seen them picking up the pace with 30 decisions published, and they have already issued 12 decisions this year. So at this rate, quick math, we'll end up at around 36 decisions this year. The Litigation Chamber has indicated that it wants to pick up the tempo even more. It has stated that it wants to spend about 3 months per case, except in complex matters. Now, for those of you who have experience before the Litigation Chamber, you will have noted that the tempo of the procedure is actually quite fast. Typically, the DPA gives you 30 days to submit your trial briefs after you are first notified of the fact that a case is pending against you. Now, in our experience, this is already quite stringent. And in this context of dealing with cases rapidly, we see that the DPA often makes use of prima facie decisions. Now, these are decisions that the DPA takes before starting a procedure on the merits, where it considers that at first sight, there might be an infringement of the GDPR. The DPA will notify the controller of this potential infringement and will order the controller to set it right. So as a controller, you're not really involved in the prior analysis of the DPA. And typically you get 14 days to comply with the prima facie decision. And if you don't, for example, because if you don't agree with the decision, the litigation chamber can start a procedure on the merits. And these prima facie decisions are often made in straightforward cases, for instance, where a data subject right needs to be complied with. Okay, so next slide, please. So how has the DPA fared so far in terms of financial penalties? And this table illustrates what GDPR topics have given rise to financial penalties the most. Unsurprisingly, we've seen that out of all the fines that have been published, which 31 so far, the most are issued for non-compliance with general data protection principles. These are the basic principles in Article 5. After that comes the lack of an appropriate legal basis for processing, Article 6 of the GDPR, and then problems with transparency and compliance with data subject rights come on a shared third place. All right, so next slide, please. This next slide shows how Belgium has fared so far compared to other EU member states. Unfortunately, it's not always clear whether public data on the topic is exhaustive, but on the basis of what we could find, we can certainly see some very interesting trends. First, when comparing Belgium to other countries, we see that the number of fines issued in Belgium is disproportionately high. For being such a small country, our Belgian DPA has issued more fines than France and the Netherlands combined. However, when we look at the amount of those fines, we see that Belgium scores incredibly low compared to Germany, where a similar amount of fines has been issued. Belgium has only 1/50th of the total value of those fines. The average amount per fine is a lot higher in other countries, for some countries up to 100 times higher. Of course, there have been some decisions in our neighboring countries that significantly influence this number. For example, the penalty of Google of 50 million euros. But nonetheless, these trends are striking. And it shows that maybe the strategy in Belgium is quite different from other member states, that they seem to take the approach of issuing many small fines rather than issuing a few fines for very large amounts. All right, so if you take us to the next slide, please. So what determines the height of the fines issued by DPAs? Well, the criteria are the same for all DPAs. In fact, they're listed in Article 83.2 of the GDPR. So for example, some obvious aggravating factors are the negligent or intentional character of an infringement. Is it the first time that a controller commits the infringement, or is he a repeat customer? And then on the other side, there are also some attenuating factors. For example, have you cooperated with the supervisory authority? Have you taken mitigating measures beforehand or in the course of the procedure? Now, we'd like to stress here that these factors can certainly influence the decision for the better. As we've seen in the case law and in our experience, it's worth taking your time to respond diligently to the questions of the litigation chamber. This can absolutely make a difference. And this also goes for elements that may be part of the inspectorate's investigation, but that are not included in the scope of the procedure before the litigation chamber. So it can occur that the litigation chamber does not address every finding that the inspectorate has included in its investigation report, but to the extent that you can respond to those findings without incriminating yourself, it may be worth doing so as well. And then finally, it's always a good idea to be able to show what mitigating measures you have taken to address some of the obvious legitimate concerns of the DPA during the procedure. So when you're in the process of responding to the litigation chamber, in parallel, it can be worthwhile to investigate whether there are any low-hanging fruits that you can pick, some mitigating measures you can already take to satisfy the DPA to at least some extent. All right, so this takes us to the next topic. The case is the appeal before the market court. So far, there have been 17 judgments by the market court published on the website of the Belgian DPA. And out of these 17 judgments, in 11 of them, the appeal was declared well-founded and the decision of the DPA annulled. Now, throughout the jurisprudence of the market court, we can see that the Belgian DPA is still very much on a learning curve. Quite often, the Belgian DPA's decisions are overturned, not because of a wrong interpretation of the facts or a wrong application of legal principle, but because of problems with the principles of good administration. In 12 of the 17 judgments, the market court has pointed out some serious flaws in the decision-making of the Belgian DPA. Now, the flaws can range from an inadequate formal motivation, but also problems with the right of defense, the right to be heard, the principle of proportionality, even the principle of impartiality. And in its decisions, the market court has been quite critical for the DPA. And this illustrates painfully that the DPA is still undergoing some toothing aches. The decisions also highlight that the litigation before the Belgian DPA not only requires a knowledge of data protection law, a good knowledge of administrative law and even criminal defense law is also important when litigating before the DPA. In many of its judgments, the market court has also clarified the nature of the appeal against the Belgian DPA's decisions and its powers to overturn those decisions and issue decisions of itself. Now, without going into full detail, it is worth mentioning that the appeal before the market court is not the same as a regular judicial appeal, as we know it from the judicial code. In a regular appeal, the appellate judge has the possibility to review the dispute in its entirety in both fact and law. like a second opinion, if you will, where even new elements can be brought to the attention of the appellate judge. It's not quite the same with the market court vis-à-vis a DPA's decision. The market court exercises judicial control over the DPA's decisions. It will assess whether principles of good administration have been respected, whether the facts have been correctly represented, is the decision of the DPA well founded in those facts, or is there a manifest error in the appreciation of the DPA, and whether the legal qualification of those facts is correct. Before it can consider replacing a decision with one of its own, it is necessary that the contested decision be either irregular or illegal. When it decides to replace a decision, it can only do so within the limits of the legal debate. In other words, it cannot raise new issues that have not been subject of a debate before its court. Now, especially for decisions where there is a margin of appreciation for the DPA, the market court is more limited in its options to replace. Such discretion is at hand, for example, when choosing the right sanction or choosing the height of a potential fine. And in those cases, the market court assessment will be more limited to an analysis of compliance with the principles of good administration. So onwards to the last slide from me. What can we expect for the future from the Belgian DPA? So the first point on the slide is something that is fairly new. Since the end of last year, the Belgian DPA has added a new tool to its arsenal. It has concluded a protocol with DNS Belgium, which is the entity managing domain names in Belgium. Via this protocol, the DPA can now take down websites of controllers or processors that do not comply with the GDPR. This happens through a so-called notice and action procedure, and it's an extension of the powers of the inspectorate or the litigation chamber to suspend, limit, freeze, or seize a data processing activity. And it could be seen as a final remedy when you do not comply with such an order. Obviously, this is a pretty far-reaching tool, and the implications for entities that rely on their website to conduct their business can be dire. So it's worth keeping an eye out for how this will be used in practice. And if you'd like to know more about this, we've just released a blog post on the topic, and we've included a link at the end of this presentation. On the next point, for some time now, the DPA has been indicating that it wants to adopt a more proactive approach. So this would mean on-site visits of the inspectorate or broad thematic investigations spanning multiple controllers. On the second point, the DPA has recently conducted an investigation of 20 of the most visited media websites in Belgium for the compliance with the rules on cookies. On the on-site visits, the DPA already indicated this in July 2020, but of course it has been difficult, firstly because of COVID, but secondly also because of a high workload for the DPA. Which brings us to the next point. We see that the DPA is still indicating that it is understaffed and underfunded, and as a result of which it has to prioritize. And in that regard, it's worth noting that the DPA intends to issue a formal policy on dismissals. And then more interestingly, the DPA wants to develop a methodology to allow the litigation chamber to objectify the choice of sanctions as well as the level of possible fines. So this might be really interesting in light of what we have seen before on the level of fines, especially where as a part of this exercise, it wants to do a benchmark of other EU member states and sectors. So who knows, maybe in the future we can expect a similar system as in Germany, where it's possible to calculate a fine beforehand via formula. It remains to be seen. All right, so that's it from my end. And with this, I happily give the word to Tim, who is going to kick off with an overview of some noteworthy decisions of the Belgian DPA.
Thank you very much, Louis. Indeed, let's have a look at some of the decisions. As Louis explained, we've already seen a lot of decisions, and obviously quite a lot of those decisions are rather anecdotic. So it's not always useful for the wider public to draw lessons from them. But we thought there were 7 decisions that we wanted to briefly touch upon because we believed they were particularly interesting. Now, the first case is probably the best known one, the so-called Jubel case, in which the DPA addressed the topic of cookies. In that decision, which dates from end of 2019, it made it clear that, first of all, your cookie consent must be granular, so you need to get one consent for each category of cookies. And secondly, that pre-ticked cookie checkboxes are unlawful. But I believe, or we believe, that the most interesting part is the very strict position that the Belgian DPA has taken regarding analytic cookies, so the so-called audience measurement cookies. Actually, many DPAs in other member states are not, or at least not actively enforcing this topic, partly because of the fact that under the proposed e-privacy regulation, the use of those cookies would be allowed without the need for consent, obviously subject to certain conditions. Well, this is not the view that the Belgian DPA has taken, so it is simply enforcing the law as it stands today, and so it considers that analytic cookies require consent. Now, the second decision is about the position of the internal DPO. So here the Belgian DPA has decided that there is an inherent conflict, and those are the words of the Litigation Chamber, an inherent conflict if the DPO is also head of a department. In this particular case, the DPO was also head of audit, compliance, and risk, but really it could be any other department. And the reason, according to the DPA, is the fact that there would not be any independent DPO oversight in those departments regarding the processing activities that are taking place there. Well, I think it's fair to say that this decision sparked a lot of controversy. I personally still have an issue with the fact that the DPO could not be also head of compliance, because in my view, those roles are very similar, but unfortunately, the decision was not appealed before the Market Court, and so we sort of have to live with it for now. Now, there seems to be a little bit of margin of maneuver with this decision. If you implement a, let's say, solid conflict procedure, then you would be allowed to still combine those roles. But what is clear, because the decision doesn't really explain in detail how that should be done. So what is clear is that if you want to exclude your risk, you would better appoint a DPO who is not also head of a department. Now, obviously, it's important to stress that this was a case where there was where it was legally required to have a DPO. So in itself, and despite the fact that the Data Protection Authority has identified the topic of DPO as a priority in its strategic plan, I wouldn't necessarily argue that companies who have not appointed on a voluntary basis a DPO would have a higher risk of being scrutinized and investigated. Okay, so that was the first decision about DPOs. There is also a second decision about DPOs, but this time about the external DPO. Now, obviously, the advantage of the external DPO is that you avoid the whole conflict issue that I've just discussed in the previous decision. But if you appoint an external DPO who is staffed by a service provider, which will typically be the case, so it will typically be an independent person, but being staffed through a service company, well, in that case, don't simply rely on the assessment that has been conducted by the service provider. They will, of course, tell you that this individual is best placed and the best experts to help you as your DPO. But what the Litigation Chamber decided is that to meet your accountability obligation as controller, you yourself must also assess and document that this individual has the required professional qualities. For instance, the fact that he is an expert in data protection law. The other thing that the DPA ruled is the fact that filing an annual report to the board is insufficient when it comes to independence. And so your DPO, whether it's an internal or an external DPO, should have access to the highest management levels on an as-need-be basis. So whenever the DPO considers it is important, it should get access to those highest management levels. Okay, then we have two decisions about employees that I want to briefly mention. The first one deals with a disgruntled employee who filed a very large and broad data subject access request. almost, if you read the decision, by way of sort of personal vendetta against the soon-to-be ex-employer, but at that time still employer. And in this case, the employer had provided most of the information requested, but it had also invoked the exemption stated in GDPR, on the basis of which it does not have to provide certain information if it would harm the interests of other parties. And also the data controller, the employer, said that with regard to some of the data that was being requested, the request as such was formulated too broadly and too vaguely, and therefore it didn't meet the request. Now, in all fairness, in this decision, I think, and it's a quite recent decision, I think the Litigation Chamber adopted a quite balanced and pragmatic approach and decision. First, it decided that employers should not rely on the exemption too quickly. So don't refuse providing data too quickly because it might harm the interests of others. As the Litigation Chamber, I think, rightfully stated, redacting the info is typically better, as that allows you to reconcile, on the one hand, the interest of the data subject, and on the other hand, the interests of third parties. Second, the employer was not obliged to communicate all IT logs according to the Data Protection Authority that related to the employee, so the IT logs relating to his use with the IT systems, because according to the DPA that would require a disproportionate effort, and the employee did not justify why it was important to get access to those IT logs. So they're a quite reasonable, dare I say, point taken by the Litigation Chamber. And then lastly, with regard to the request to get access to all the incoming and outgoing emails, where the DPA said that the employer cannot reject that request purely on the basis that the employee has access to the emails itself through the email system provided by the employer. That was in itself not sufficient to deny the exercise of the access rights. However, and that is obviously quite interesting and useful for employers, you are allowed to reject this kind of request on the basis that it may compromise trade secrets, but obviously, again, think about striking a balance, and so redaction may be required in certain cases. The second case is a very interesting one to the extent that it condemns a common practice, I would say, in the world of HR. According to the Belgian DPA, when you interview a candidate, you are not allowed to ask the ex-employer for a reference unless you have obtained the consent from the candidate. I have to say that personally, I really find it surprising that the DPA considers that in this case, a consent might be valid, because in my view, there is a clear imbalance between both people, the future employer and the candidate. And I think that relying on the legitimate interest as future employer would suffice. Obviously, you also have to inform the candidate about the fact that you will do the reference check, but I think those two combined should suffice, but unfortunately, this is not what the Belgian DPA decided. My next case is about direct marketing and privacy notices. This is a case where the Belgian DPA decided that offering a granular opt-out for direct marketing for each type of communication is insufficient. So one opt-out for emails, one opt-out for SMS, one opt-out for phone calls, that doesn't suffice. You also have to offer a consolidated opt-out, which is basically an opt-out across the board for all types of direct marketing. In addition, in this particular decision, the Belgian DPA also took advantage of the fact that it could give some actually practical recommendations to the wider data protection community. It says it with those words in the decision. It's really addressing itself to the data protection community, and it clarifies how organizations, data controllers, can ensure that the transparency requirements in the context of privacy notices are met. It gives practical tips, the use of 2 levels in your privacy notice, a first level with some summarized basic information, and then a second level that you can click through, which contains more detailed information. And then finally, as you can see, there have been many decisions around surveillance cameras. I won't go into the detail of each of those decisions, but I think the key message is that data controllers really have to be extra careful when they implement surveillance cameras. Make sure you comply with the principles of data protection by design and by default. Conduct your data protection impact assessment. Make sure you have an entry in your register, and obviously make sure you meet your transparency obligations. Okay, so moving on to our next topic then, how does the DPA conduct its inspections and how does the litigation chamber operate in practice? Now, by way of recap on this slide, you can see the enforcement process. And obviously the 2 crucial bodies are the inspectorate and the litigation chamber. The former is charged with investigating potential data protection infringements. You could think of it as the public prosecutor and a team of inspectors, team of police if you want. And then the litigation chamber is the administrative body that is acting as an independent judge. Now, as we have seen, inspections are typically triggered by a complaint, which is filed by a data subject. It could also be an enterprise, for instance, a competitor. And it is then typically sent to the inspectorate for investigation, although, as Louis explains, in certain cases, it can be sent to the litigation chamber directly if the case is simple and straightforward. Now, inspections may also be triggered by the first line service, and that is in cases where the reconciliation attempt has been unsuccessful. That is the orange arrow on the slide. And then, well, as you can see, the litigation chamber always has the option to send a file back to the inspectorate if it considers that additional investigatory measures are required. In principle, the litigation chamber is not allowed to conduct investigatory measures itself, although we have already experienced that it really tries to stretch those powers in that regard. In any event, it is always the litigation chamber who will take the enforcement decision as such, and it can either decide, as Louis explained, to dismiss a case, or can pronounce a warning or a sanction. And as you probably know, those sanctions may vary from a simple reprimand all the way through to administrative fines. And then finally, if you're unhappy with a DPA's decision, you have 30 days to file the appeal before the market courts. Okay, so let's now have a closer look at how inspections are being conducted. At the moment, an inspection is mostly a paper-based exercise. So basically, you will receive a letter from the inspectorate with a series of questions that you have to answer. There are often a lot of questions, and as Louis explained, the scope is not always limited to the, let's say, initial issue that was stated in the complaint. You can obviously always ask for a meeting to discuss the matter with the inspectorate. Technically speaking, it's not really a meeting, it would be an interrogation, but the fact is that in reality, in our experience, this request is always rejected. We suspect that this is linked to the issue of under-resourcing. It would take more time from the inspectorate. Okay, so questionnaires, and in addition to the questionnaire, there is sometimes a so-called technical expertise. The inspectorate has people with an IT/technical background who sometimes are tasked with analyzing, for instance, the website of the controller to draw findings and conclusions in that regard, but really from a technical point of view. And then perhaps surprisingly, Louis already mentioned this, the inspectorate currently hasn't conducted on-site inspections, again linked to the issue of under-resourcing, but we might see them coming in the future. Who knows? Time will tell. Good. So what else should you know? I think it's really important, and I cannot stress this enough, how much the inspectorate puts a huge, and in my personal view, an unrealistic focus on documentation and on DPO advice, obviously assuming that a DPO has been appointed. It really sometimes feels as if the expectation is that you have to document every single step that you take. We've seen examples where a controller was asked a copy of the breach risk assessment. Why did you or did you not notify the breach? That's something which I might understand, but also requests of minutes of phone calls between the DPO and the commercial team, for instance, which in my experience are quite often inexisting. And also a lot of requests around written policies for processes, where I know that many organizations have not created those processes because, or those policies, because it's self-evident how the process will unfold itself. And if you look at, for instance, the documentation of the assessment of professional qualities, this was a particular case where a company had appointed a DPO. This was a person who had been a data protection lawyer in a tier 1 law firm, had then joined the company and worked on the GDPR implementation project for 3 years full-time. And then in 2018, it was just bleeding obvious that this was the perfect candidate to be appointed DPO. So there was no formal assessment. Everyone just knew that this was the person. Well, this was something which the inspectorate didn't understand. They were really seeking to find documentations, decisions taken by the boards or by management as to why this person met the requirements and how this assessment had been done. Okay, so you get all these questions, requests for documentations, and you get very little time to respond. By default, it's 1 month, which really isn't a lot of time because you will need to dig up information, sometimes in your archives. People have left the organization by now. It's difficult to find the information. You need to talk to different departments, draft a letter, etc. You can ask for an extension, but it's certainly not always granted, and I would say by default, rather not granted, because unless you are really able to justify exceptional circumstances. Added to that, bear in mind that the fact that you don't meet the deadline is typically considered by the inspectorate as an infringement of a specific GDPR provision, which is the legal obligation to cooperate with the supervisory authority. So that's not really helpful either. So by way of conclusion, I think when dealing with the inspectorate, it's really important that you bear in mind that it will essentially and mostly investigate a chapter. The inspectorate is not your friend. It's not necessarily your enemy, but it's certainly not your friend. And you have to approach them and interact with them as if you were acting with police investigators who are investigating a potential crime. So it means that you have to be extremely careful to draft your response to the questions. You have to be complete enough. You have to answer the questions, but make sure you don't provide more information than is asked. Don't go beyond the question, beyond the scope. Because if you do provide more information, well, that is opening the door for the inspectorate to add potential additional alleged infringements to the scope of its investigation. Obviously, that's something you want to avoid. And also, the reason why you have to be very careful is that in our experience, the inspectorate takes its role very seriously. It has, in my view, a quite, can I call it idealistic view of data protection compliance. And I find that it doesn't always understand the practical reality of how organizations operate. So once it has started its inspection, it also seems extremely determined to find GDPR violations. And let's be fair, if you dig long enough, at some point you will find an infringement in any organization. So If you ever receive one of these letters, I think the key message is don't sit on it, don't take it lightly. There's no need to panic, there never is a need to panic, but you have to be aware that this might be the first step towards a potential sanction. So it shouldn't be taken lightly, and obviously it should get absolute priority despite all the other urgent things that you have on or may have on your to-do. Good, so let's now have a look at what to expect when you deal with the litigation chamber. Now, the procedure there is typically initiated when you receive a registered letter. Sometimes you will be aware of the investigation because you've already been contacted by the inspectorate, but that's not always the case. And so this letter will contain the lists of articles which are allegedly infringed, a copy of the inspection report, and often also a series of questions that the litigation chamber wants you to answer. Now, unfortunately, it's not always clear what you should be defending yourself against. Given, let's say, the determination of the inspectorate to find infringements, the inspection report will typically contain more alleged infringements than what is referred to in the letter of the litigation chamber. And the letter is not always clear whether you should only focus on those that are in the letter of the court, of the litigation chamber, or whether you should focus on all the alleged infringements that have been put forward by the inspectorate, the, let's say, public prosecutor. What doesn't help either is the fact that the inspection report is not always well structured. So as a defendant, it is often really a struggle to try and find which are the alleged infringements. We actually even had one case where neither the inspectorate or the litigation chamber had expressly identified the specific article that was allegedly infringed. They merely referred to an infringement of the so-called collaboration duty, but as defendants, we had to find ourselves which article in the GDPR that would be. I know that if this would happen in a criminal procedure, this would be a clear violation of the rights of defense. According to the litigation chamber, this is not a problem in an administrative procedure. The market court hasn't had to decide on this. We'll see. I remain skeptical. Okay, so the hearing. What is interesting with regard to the hearing, the Belgian law on this proceeds in a written procedure. So normally it's by default a written procedure. However, and I guess that's the good news, if you ask for a hearing to plead your case, then as far as I know, that request is always granted. The hearing itself is not open to the public, so it's just you and the litigation chamber. That's also interesting. The inspectorate is not present, and so the inspectorate will not plead or order why it believes that you infringed the GDPR. It will not propose a fine, so that's a clear difference between, let's say, criminal proceedings. You are there alone with the litigation chamber, and you get ample time to plead your case. That hearing is a bit more informal, I would say, than a regular court hearing, but also very interactive. The chamber is composed of 3 people typically with various professional backgrounds, and they ask a lot of questions, often very practical questions, factual questions about how your organization is structured or organized. So it's important that you carefully assess who attends the hearing. If you have to defend yourself on an issue around marketing, for instance, it may really be a good idea to bring a colleague from marketing who can explain how they typically work on a factual basis. Obviously, it's important to brief that person properly, but it can really be helpful. So sometime after the hearing, you will get a report, and if which sort of summarizes the hearing, you can comment on that. And if the DPA intends to issue a fine, you also get a notice in which it will justify the amount of the fine. Again, you have the opportunity to comment on it, not on the merits, so you cannot say, well, we disagree that we should receive a fine, but you can explain why you believe that a fine should not be needed or why the fine is too high. for instance. And then ultimately you get a copy of the decision. There's no fixed determined timeline for this in the law. It may actually take quite long. Several months is not an exception, and certainly not if the decision needs to go through the consistency mechanism where DPAs and other member states may have to review and comment on the draft decision. And then finally, decisions are typically published online almost immediately after you receive it as defendant. So make sure that your PR team or comms team is prepared, because although, as you probably know, the DPA typically anonymizes, well, quote unquote, the decision. What we have seen is that in the more substantial, the more significant cases, the press has always been able to almost immediately find out who the defendant is. Makes you wonder who breaches confidentiality. That's a different debate. So in any event, it's quite important that you are prepared to make a statement to the press if necessary. So to wrap up, and before we open it up to questions, what are our top tips? Well, I think generally speaking, outside of the context of any enforcement procedure whatsoever, what we really have learned is how important it is from the DPA's perspective to document, minute, and justify as much as you can. If there is an inspection, you will have to be able to present written evidence that dates from the time when a decision was taken. So it doesn't suffice that the decision as such was sound at the time when it was taken, and that when the question is asked, you're able to justify and explain why the decision was taken. No, you have to be able to produce evidence that was put together at the time when you took the decision. So document. That is, I think, really the top tip. But of course, be careful about how you phrase it, because if they ask for it, they may use it, and they may use it against you. So specifically, specific advice for DPOs or legal counsels within an organization who advise on privacy, I would recommend to avoid providing your DPO advice in response of a long email chain with many other colleagues in business departments. We've had these kind of examples, and actually it's rather annoying if the DPO advice that has been provided is really sound and useful, but if it is included in an email chain where some of the other colleagues in marketing or in HR is making comments in the chain in such a way that suggests that perhaps data protection compliance is not considered important. That's not something that you want to share with the inspectorate or the litigation chamber, of course. Now, so that was the sort of general side comment. Specifically, when you deal with an enforcement procedure, as Louis already sort of suggested, we recommend this three-tiered approach, which in our experience sits well with the DPA. Whenever possible during the enforcement procedure, try to implement improvements as a token of goodwill. Obviously, it's important that you specify that you do it without prejudicial recognition, but it's really much appreciated in our experience. If you're unable to implement those changes during the procedure, it may be a good idea to present them as part of a sort of continuous improvement plan in your submission to the litigation chamber, again, with while stressing that you're doing this without prejudicial recognition. And then finally, really make sure that you collaborate. It is crucial, not only because you avoid being sanctioned for lack of collaboration, but also because it will create goodwill. And if a fine or a sanction is imposed, it might be a less hefty sanction. So what that means is that you have to reply in detail, make sure that you always respond, that you respect the deadlines, but that you are very careful about how you do it. And I think that brings me to the last top tip, and also a bit of light relief at the end of this webinar. What you really should not be doing is make fun of the DPA or actually offend them. There is one decision, it's case 32/2020 for those of you who are interested, where a defendant first ignored several letters from the inspectorate, never replied to them, never replied to a letter from the litigation chamber, and then when it was summoned by the litigation chamber to present its defense on the merits, the reply it gave, and I'm quoting, well, obviously after having translated it, but the reply was, "Are you serious right now? What are we talking about here? A promotional email? And then we're surprised that the world is going to hell." I think it won't come as a surprise that this is one of the cases that is in the statistics of Louis. This person was sanctioned, not obviously just because of this statement, but it's quite clear, I would say, that the statement didn't help him avoid the sanction. Okay, and so with that said, we have come to the end of our webinar. Louis already hinted out to some of the articles that we wrote about different topics that we discussed on our blog or in some legal reviews. And I'm happy to open it up to questions. Let me have a look. I see that we already have a few questions. So a first question that I'm seeing here is with regard to the reference check from ex-employer. When you interview a candidate without consent, is it different if you obtain the reference when you have made the offer to the candidate? Well, it's a good question. I'm not sure whether in practice it will timing-wise always go like that, because typically I would imagine that an employer, a future employer, wants to do the reference check before the offer is made. I don't think that the timing in any event is really of much relevance. I think if you look at the DPA's decision, their point of view is that you shouldn't reach out to individuals unless they have agreed to it. Obviously, one thing that you can do, and which may be a way to sort of get around this practical issue, is to ask any candidates to come up with a few names that they can agree on, but in a way that is sort of constituting a consent. If they don't present any, referee, I think you really need to be careful. Personally, I'm not convinced that this decision would stand the test of market court scrutiny, but well, that's my personal view. I think if you want to do it, I think it's absolutely crucial that you are completely and fully transparent about it. So what that means is that you inform the individual that you will contact person X as a referee, and that secondly, you sort of circle back to the candidate with the feedback and also offer them the chance to comment on it. I think if you do that, you have, let's say, acted in good faith, you have been transparent. I would be surprised that you get in trouble despite this decision, but well, what is clear is that obviously even then doing it is a bit of a risk considering the decision as such. It's still not fully in line with the decision, but from my perspective, it would be defensive. Okay, just looking. All right, yeah, so this is a good question. So a hearing before the litigation chamber is possible. Indeed, you can ask for it, but is it always a good idea to ask for a hearing? That is a good question. I would say that in most cases, it may help you because it's always good. I mean, those people in the litigation chamber who are your judges, they need to take a decision, and if they are able to see you and see who you are and you obviously are assuming you are able to make a good impression, I think it will help you. Obviously, if the infringement is incontestable, you might argue is it then needed to go, but I think even in those cases, it may be useful to go there, if not only to sort of apologize. Obviously, don't go there then and deny the light of the sun and say, well, there is no infringement if it's bleeding obvious that you didn't comply with your requirements. But even in those cases, I think it could help. For instance, because you can convey the message that you've understood, okay, something happened and it shouldn't have happened, but you have taken lessons from this. This is the plan that you are implementing or that you plan to implement to ensure that it doesn't happen again, etc. I think that may help you end up with a more positive outcome, which means a less strict sanction. Okay, and then I see there is also another question on legitimate interest. That might be an interesting one because it's a tricky topic. Let's have a look. I have the impression that legitimate interest as legal ground, especially in direct marketing, but apparently also in the reference case with the employer, is structurally denied by the Belgian DPA. What's your view on this? Yes, so this is a tricky question. I think, I mean, it's legitimate interest is a tricky one. It's not only the Belgian DPA, I would say. If we go back to the time when GDPR was still being discussed and it was still a draft text, some of you may recall that the European Parliament at some point basically wanted to change the principle, and so as in terms of lawful ground, where now all the lawful grounds, whether it's consent, legitimate interest, or contractual necessity, they have the same value, and if you're able to rely on one of them, it's enough. The Parliament had proposed that consent should be sort of the default position, and all the others should be exceptions. So legitimate interest has for quite a while been regarded as dare I say something nasty. So I think that is a reality. We're seeing this not only at the level of the Belgian DPA. On the upside, if you look at the case law of the Court of Justice, there are certain decisions where they clearly recognize that legitimate interest may be relied on. We know that the Belgian DPA or the Privacy Commission beforehand issued recommendations where they recognize that it can be relied on. So I don't think it's a good idea to try and avoid it. And in certain circumstances, you won't be able to avoid it because there's no alternative. But what is clear is that the so-called legitimate interest assessment will be crucial. You will need to be able to justify why your legitimate interest prevails over the rights of the data subject. And this goes back to the top tip around documentation, of course. It is extremely important that you're able to produce that document which dates from the time when you decided to go for legitimate interest, and not an explanation that dates from the time when you are asked a question by the regulator. All right, and then have a look and see, we have a few more minutes. Okay, so one of the questions that's an interesting question, we didn't address this indeed, is the DPO involved in the inspection or the procedure before the litigation chamber? And if so, how is the DPO involved? It's not entirely clear. Louis and I have had the example this week where for some cases, the DPA has reached out to the DPO, which has been notified. So the DPA has the contact details of the data protection officer. So if there is an issue and the GDPR states that in principle it should be the person that they should communicate with, and vice versa. So in principle, you would expect that if there is an issue, the questionnaire is sent to the DPO. Just this week, we had a case where actually a prima facie decision was not sent to the DPO, but was sent to the CEO. So it really depends. I think so. Well, the DPA doesn't always involve the DPO as such. I think the other question is, does it make sense for you to involve the DPO? I think it depends on the facts of the case. In certain instances, it will be useful if there are questions around certain advice or why a decision has been taken. It may be helpful that the DPO is there to explain why certain advice was given, why a breach was flagged or evaluated as being a low-risk breach, for instance. But obviously, what you should avoid is a situation where the actual issue, let's say, was because HR had done something which they shouldn't have done, and that you only send the DPO to explain to the hearing why that happened. I think in those cases, it's probably best to also have someone from HR, but there are no real rules, so it's up to you to choose. To my knowledge, the litigation chamber has never required the DPO to be present, and I think in the end it's also a bit of gut feeling. You need, if you think of those US court films where they really test people before they put them on the witness bench, etc. I think you don't necessarily need to go that far, but it's good to sort of carefully consider who attends the meeting, not just in terms of what they know about the organization, but also in terms of how they are able to present this in a way. So some people, when they start speaking, they are unstoppable and they start saying things which they should better not say. So, I mean, assess who you send, and obviously make sure that they are well prepped. That is a key point. Voila. So I think looking at the time, I'm afraid we will need to wrap up here. I hope you found it useful. We certainly hope that even if you found it useful, that you won't have to use it anytime soon, because that's obviously what we all try to avoid. But if it does happen, if you do receive the letter, we hope that you learned some things during this webinar. If you have additional questions, feel free to drop Louis or myself a line, and otherwise I hope we'll be able to meet each other soon, whether at one of our next webinars or hopefully in person very shortly. Thank you all for attending, and see you next time. Bye.